I knew something was wrong the moment I saw Patricia Thornton standing at my front door at 7 in the morning, clutching her tablet like it was the holy grail of neighborhood violations. The snow had barely stopped falling an hour ago, and I had just finished plowing my driveway, pushing the white powder onto my own front lawn where it belonged. Now here she was, the president of the Meadowbrook Estates Homeowners Association in Aurora, Colorado, looking like she had caught me committing a federal crime. "Mr. Lawson," she said, her voice sharp enough to cut through the cold morning air. "I need to speak with you about a serious violation." I stood there in my doorway, still holding my coffee mug, steam rising into the frigid air. "Good morning to you too, Patricia. What seems to be the problem?" She tapped on her tablet with manicured fingernails painted an aggressive shade of red. "You have violated Section 14.3 of the Meadowbrook Estates HOA bylaws regarding snow removal and placement. I have photographic evidence that you plowed snow from your driveway onto your front lawn, creating an unsightly pile that exceeds the allowable height restrictions for lawn ornamentation." I blinked at her, trying to process what I had just heard. "You mean the snow on my own property?" "The snow I removed from my driveway so I could get to work. The bylaws are quite clear, Mr. Lawson. All snow must be distributed evenly across the property to maintain aesthetic uniformity throughout the community. Large piles are expressly forbidden as they create visual disruption and may negatively impact property values." I took a long sip of my coffee, buying myself time to respond without saying something I would regret. I had lived in this subdivision for 3 years, and Patricia had been a constant thorn in my side. She had fined me for having my trash cans visible from the street on a non-collection day, even though I was literally in the process of bringing them back from the curb. She had cited me for having a garden gnome that was supposedly not in keeping with the community's aesthetic standards. She had even tried to fine my neighbor for having the wrong shade of tan paint on his house, claiming it was too beige rather than the approved desert sand color. "Patricia, that's the most ridiculous thing I've ever heard. It's snow. It's going to melt in a few days anyway." She thrust the tablet toward me, showing a grainy photo of my front yard. "Nevertheless, you are hereby fined $500 for this violation. You have 10 days to pay or the fine will increase to $750. Additionally, you must redistribute the snow immediately to comply with community standards." "I'm not paying a fine for putting snow on my own lawn." Her eyes narrowed. "Then you leave me no choice but to escalate this matter. The HOA board will be meeting in 3 days to discuss your continued violations and potential additional penalties. Good day, Mr. Lawson." She turned on her heel and marched back down my driveway, her boots crunching in the fresh snow. I watched her go, feeling my blood pressure rising despite the cold morning air. This was insane. I had specifically bought in this neighborhood because it was close to my job as an IT consultant in downtown Denver, not because I wanted to deal with petty tyrants obsessed with snow placement. I went back inside and called my neighbor, Mike Peterson, who had warned me about Patricia when I first moved in. He answered on the 3rd ring, sounding groggy. "Mike, it's Wyatt. Sorry to wake you, but Patricia just fined me $500 for plowing snow onto my lawn." There was a long pause. "You're kidding." I wish I was. She said it violates some bylaw about snow distribution and aesthetic standards. Mike let out a low whistle. "Man, she's really gone off the deep end this time. Listen, she tried to pull something similar with the Hendersons last year. They had to hire a lawyer and it cost them $3,000 to fight it. What happened? They eventually won, but it took 6 months and a lot of stress. The HOA has pretty deep pockets because of everyone's dues, so they can drag these things out forever." I felt my stomach sink. I did not have $3,000 to spend on fighting a ridiculous snow fine. This is crazy. There has to be something I can do. You could try going to the board meeting and appealing to the other members. Patricia doesn't always get her way, especially when she's being really unreasonable. But fair warning, she usually stacks the meetings with her friends who will back her up no matter what. After I hung up with Mike, I spent the next hour researching Colorado HOA laws and the Meadowbrook Estates bylaws. What I found was both enlightening and infuriating. The bylaws did indeed have a section about snow removal, but it was vaguely worded and seemed primarily concerned with keeping sidewalks and common areas clear. The section Patricia had cited, 14.3, was about aesthetic maintenance standards during winter months, and it mentioned that excessive accumulation of snow in visible areas may be deemed a violation if it creates visual disruption. The problem was that excessive and visual disruption were completely subjective terms. By that standard, Patricia could fine anyone for anything related to snow. I also discovered that under Colorado law, HOAs were required to follow their own bylaws consistently and could not selectively enforce rules. If I could prove that other homeowners had similar snow piles and were not being fined, I might have a case. I grabbed my phone and drove around the neighborhood for an hour, documenting every single snow pile I could find. There were dozens. Nearly every house that had been plowed had snow pushed onto the lawn or along the edges of the driveway. Some piles were even bigger than mine. I took careful photos with timestamps and GPS coordinates, building my evidence. The board meeting was scheduled for Thursday evening at the community center, a small building near the neighborhood entrance that was used for various HOA functions. I showed up 15 minutes early, armed with a folder full of printed photos and copies of the relevant bylaws I had highlighted. The meeting room was set up with a long table at the front where the board members sat and rows of chairs for residents. About 20 people were scattered throughout the room, most of them looking bored or annoyed to be there. Patricia sat in the center of the board table, flanked by 4 other members. I recognized 2 of them, Helen Crane and Donald Matthews, as generally reasonable people I had chatted with at neighborhood events. The other 2, Joyce Winters and Robert Finch, were Patricia's usual allies and had a reputation for rubber stamping whatever she wanted. Patricia called the meeting to order and droned through various announcements about landscaping standards, upcoming community events, and the proposed budget for next year's common area maintenance. Finally, after nearly 40 minutes of tedium, she reached my case. Item 7 on the agenda concerns Mr. Wyatt Lawson of 4782 Meadowbrook Drive and multiple violations of community standards. Mr. Lawson, you are here to address your recent snow placement violation and discuss your pattern of non-compliance with HOA regulations. I stood up, holding my folder. Thank you, Patricia. I'm here because I believe this fine is unjust and represents selective enforcement of vague bylaws. I have evidence that numerous other homes in the neighborhood have identical or larger snow piles on their properties, none of which have been cited for violations. I began passing out copies of my photos to the board members. Patricia's face tightened as she looked through them. Mr. Lawson, those photos are irrelevant. We are discussing your violation, not other properties. The HOA has the discretion to address violations as they come to our attention. Helen Crane, a retired teacher who had always been friendly, looked up from the photos. Actually, Patricia, I think this is relevant. If we're fining Wyatt for something that half the neighborhood is doing, we need to either fine everyone or reconsider whether this is actually a violation worth pursuing. The bylaws are clear, Joyce Winters chimed in, her voice nasal and irritating. Mr. Lawson created an excessive snow pile that disrupts the visual aesthetics of the community. I pulled out another document. I've also reviewed the exact wording of Section 14.3, and I believe the HOA is misinterpreting it. The section is clearly intended to address situations where snow creates safety hazards or blocks common areas, not routine snow removal from private driveways onto private lawns. Donald Matthews nodded slowly. He has a point. We've never enforced this particular interpretation before. I've lived here for 12 years, and this is the first time anyone has been fined for snow on their own lawn. That's because previous boards were lax in their enforcement, Patricia snapped. I'm trying to maintain standards that preserve our property values. By fining people for snow that will melt in a week, I said, unable to keep the frustration from my voice. This isn't about standards, this is about control. You've been harassing me since I moved in with increasingly petty violations. The room went quiet. Several residents in the audience nodded or murmured agreement. Patricia's face flushed red. Mr. Lawson, I will not tolerate accusations of harassment. This board operates with complete integrity and fairness. Your fine stands, and if you continue with this defiant attitude, we will be forced to consider additional penalties, including potential legal action to compel compliance. Then I guess I'll see you in court, I said, surprising myself with my own boldness. Because I'm not paying a $500 fine for putting snow on my own lawn. The meeting dissolved into chaos after that. Several other residents stood up to voice their own complaints about Patricia's enforcement tactics. Helen and Donald tried to restore order while Patricia banged her gavel and threatened to clear the room. Eventually, the board voted on my fine. Patricia, Joyce, and Robert voted to uphold it. Helen and Donald voted to dismiss it. The tie meant the fine stood. I left the meeting feeling defeated but also strangely energized. I was not going to let this go. The next morning, I contacted a lawyer who specialized in HOA disputes. Her name was Ellen Norton, and she had a small practice in Denver that focused on helping homeowners fight unreasonable association rules. Ellen's office was in a converted Victorian house near downtown. She was probably in her mid-40s, with short gray hair and sharp eyes that suggested she did not miss much. She listened to my story, reviewed my documentation, and leaned back in her chair. Mr. Lawson, I'll be honest with you. HOA cases are tricky. They can drag on for months or years, and even when homeowners win, they often spend more on legal fees than the original fine. However, your case has some interesting aspects that might make it worth pursuing. Such as, the selective enforcement issue is strong. You have clear evidence that the HOA is applying rules inconsistently. Colorado law requires HOAs to enforce their rules uniformly. Additionally, the bylaw itself is vaguely worded to the point of being potentially unenforceable. A judge might find it too ambiguous to support the fine. So what do you recommend? First, we send a formal letter to the HOA challenging the fine on legal grounds. This sometimes convinces them to back down because they realize they might lose in court. If they maintain the fine and attempt to collect through liens or other means, we can take them to court. My fee for the letter is $500. If it goes to court, we're looking at probably $3,000 minimum. I sat there doing the math in my head. $500 for the letter, maybe $3,000 more if it went to court. All because of a snow pile. But the principle of the thing gnawed at me. If I backed down now, Patricia would just keep finding new ways to harass me and everyone else in the neighborhood. Let's start with the letter, I said. Ellen drafted a strongly worded letter citing the relevant Colorado statutes and case law regarding HOA enforcement. She pointed out the selective enforcement issue, the vague language in the bylaw, and the lack of any actual harm caused by my snow placement. The letter concluded by demanding that the HOA withdraw the fine within 10 days or face legal action. Patricia's response came within a week, and it was not what I expected. Instead of backing down, she doubled down. The HOA sent a formal response through their own lawyer, a firm in Aurora that specialized in representing homeowners associations. Their letter stated that the fine was valid, that the HOA had broad discretion in enforcement matters, and that if I did not pay within the required time frame, they would assess additional late fees and ultimately place a lien on my property. "Well, she called your bluff," Ellen said when I forwarded her the response. "Are you prepared to go to court over this?" I thought about my options. I could pay the fine and be done with it, but then Patricia would have won and would likely continue finding excuses to fine me and others. I could fight and potentially spend thousands on legal fees, or I could try one more thing. "What if we filed in small claims court instead of district court?" I asked. "Wouldn't that be cheaper?" Ellen paused. "Actually, that's not a bad idea. Small claims has a limit of $7,500 in Colorado, which covers your fine and any additional penalties they might assess. The filing fee is only a couple $100. Neither side can use attorneys during the hearing itself, and cases usually get resolved within a few months. It's a lot less formal than district court. Let's do it." I filed my small claims case against the Meadowbrook Estates HOA on a Tuesday morning in early February. The snow had mostly melted by then, which felt both ironic and vindicating. The case was scheduled for a hearing in 6 weeks, giving both sides time to prepare their arguments. The HOA responded by sending me increasingly threatening letters. They formally assessed late fees, bringing my total debt to $750. They sent me a notice of intent to lien. They even sent a letter threatening to take me to court, apparently unaware that I had already done exactly that. Patricia also ramped up her surveillance of my property, driving by at odd hours and taking photos of any perceived violation. I got cited for having my garage door open for more than 2 hours during a Saturday when I was organizing my tools. I got cited for having a holiday wreath still on my door 3 days after Valentine's Day, because apparently decorations were only allowed within specific date ranges. Each citation, each fine, each petty complaint just strengthened my resolve and gave me more evidence of harassment. Ellen advised me to document everything, which I did meticulously. I kept a log of every time Patricia or another board member drove by my house, every citation, every interaction. The pattern was clear and damning. Meanwhile, word of my case spread through the neighborhood. Other residents reached out to share their own horror stories about Patricia's enforcement tactics. One couple had been fined for having the wrong type of mailbox, even though it was identical to dozens of others in the neighborhood. Another homeowner had been cited for parking his work truck in his own driveway overnight, despite there being no bylaw against it. A widow on a fixed income had been fined repeatedly for landscaping violations because she could not afford professional lawn care, and the HOA refused to let her handle it herself. I started compiling these stories, with permission from the homeowners. By the time the court date arrived, I had a thick folder of documentation showing a pattern of selective and often nonsensical enforcement by the HOA board, particularly Patricia. The hearing was scheduled for March 23rd at 9 in the morning at the Arapahoe County Courthouse in Littleton. I showed up an hour early, wearing my best suit and carrying 2 folders of carefully organized evidence. Ellen had coached me on small claims procedure. Since attorneys could not represent clients during the actual hearing, she would be sitting in the gallery but could not speak on my behalf. I would have to present my own case. The courtroom was smaller and less formal than I expected. There were about a dozen other cases scheduled that morning, covering everything from security deposit disputes to unpaid contractor bills. Patricia arrived 15 minutes before our case, accompanied by Joyce Winters and the HOA's attorney, who would also be relegated to the gallery during the hearing. Patricia wore a severe black pantsuit and carried her own folder of materials. The judge was a woman in her 50s named Sarah Mitchell, who had a reputation, according to Ellen, for being practical and no-nonsense. She worked through the earlier cases efficiently, listening to both sides and making quick decisions based on the evidence and law. Finally, at 10:30, our case was called. Lawson versus Meadowbrook Estates Homeowners Association. Both parties approached the bench. Patricia and I walked to the front. The clerk swore us in. "Mr. Lawson, you're the plaintiff," Judge Mitchell said. "Please explain your case." I took a breath and launched into my explanation. "Your Honor, I'm here because the defendant HOA fined me $500 for plowing snow from my driveway onto my own front lawn. I believe this fine is unjust for several reasons. First, the bylaw they cite is vaguely worded and does not clearly prohibit what I did. Second, the HOA has enforced this rule selectively, fining me while ignoring identical or worse violations throughout the neighborhood. Third, I believe this is part of a pattern of harassment by the HOA president." Judge Mitchell looked at Patricia. "Miss Thornton, is it true that you fined Mr. Lawson for putting snow on his own lawn?" "Yes, Your Honor, but there's important context. The HOA bylaws require residents to maintain aesthetic standards, and excessive snow piles create visual disruption that can impact property values. Mr. Lawson created a pile that was over 4 feet high directly visible from the street. You have a photograph of this pile." Patricia fumbled with her folder and produced the grainy photo she had shown me that morning. Judge Mitchell examined it, her expression skeptical. "This looks like a normal snow pile from driveway plowing," the judge said. "It exceeded acceptable standards," Patricia insisted. "What exactly are the acceptable standards? How high can snow be piled?" Patricia hesitated. "The bylaws don't specify an exact height, but this was clearly excessive. So you're using your subjective judgment to determine what's excessive." "The board has discretion to interpret the bylaws, yes." Judge Mitchell turned to me. "Mr. Lawson, you mentioned selective enforcement. Can you elaborate?" I opened my folder and pulled out the photos I had taken of other properties. "Your Honor, I drove through the neighborhood the same week I was fined and documented dozens of properties with similar or larger snow piles. None of them were cited for violations. I have photos with timestamps and addresses." I handed copies to the judge. She flipped through them slowly, her eyebrows rising. "Miss Thornton, why weren't these other properties fined?" Patricia's face reddened. "We address violations as they come to our attention. We cannot monitor every property constantly." "But you were monitoring Mr. Lawson's property constantly. We happened to notice his violation during routine patrol." I jumped in. "Your Honor, that's not accurate. Miss Thornton has targeted me specifically since I moved into the neighborhood 3 years ago. I have documentation of over 15 violations and fines in that time, most of them for minor or questionable infractions. Meanwhile, other residents with similar or identical situations receive no citations." Judge Mitchell leaned back in her chair. "Miss Thornton, This is looking like harassment rather than legitimate rule enforcement. What's the actual harm caused by Mr. Lawson putting snow on his own lawn? Did it damage anyone's property? Block anyone's access? Create any safety hazard? It created visual disruption, Patricia said stubbornly. Visual disruption is not a legal standard. What specific measurable harm occurred? Patricia opened and closed her mouth, unable to answer. Judge Mitchell turned back to me. Mr. Lawson, do you have examples of these other violations you mentioned? I pulled out more documentation, showing citations for the trash cans, the garden gnome, the garage door, the wreath. I also presented the stories from other homeowners about Patricia's enforcement patterns. Judge Mitchell read through the materials, and I could see her expression shifting from skeptical to amused to annoyed. Miss Thornton, you fined someone for having a decoration 3 days after Valentine's Day. The bylaw states that seasonal decorations must be removed within 2 days of the holiday. And you drive around the neighborhood enforcing this. It's my duty as HOA president to maintain community standards. Judge Mitchell set down the papers and looked directly at Patricia. Miss Thornton, I've been a judge for 14 years, and I've seen a lot of HOA cases. Some HOAs genuinely try to maintain reasonable standards that benefit their communities. Others abuse their power to harass residents over petty nonsense. You appear to fall into the second category. Patricia's face went pale. Your Honor, I resent that characterization. I'm simply doing my job. Your job is not to fine people for snow on their own lawns. Let me be clear about something. HOA bylaws are not criminal law. They're contractual agreements, and they must be reasonable and enforced consistently. You cannot create arbitrary interpretations of vague rules and then apply them selectively to people you don't like. That's called harassment, and it's not legal even in the context of an HOA. The judge picked up the photo of my snow pile again and actually laughed. Miss Thornton, this is ridiculous. This is a normal snow pile from normal snow removal. The idea that this somehow damages property values or violates any reasonable aesthetic standard is absurd. I'm dismissing this fine entirely. I felt a wave of relief wash over me. Patricia looked like she had been slapped. Furthermore, Judge Mitchell continued, I'm ordering the HOA to remove all late fees and to immediately cease any lien proceedings or other collection efforts. Mr. Lawson owes you nothing. But Your Honor, the bylaws clearly state, nothing clearly, Miss Thornton. That's part of the problem. Your snow rule is impermissibly vague and you're enforcing it in a discriminatory manner. If you want to have rules about snow placement, draft them clearly, specify measurable standards, and enforce them uniformly. Until then, you cannot fine people for this. Judge Mitchell then did something that surprised me. She looked at the other documentation I had provided about Patricia's pattern of citations. Mr. Lawson, I notice you've documented quite a few other violations and fines. Are you contesting those as well? I hadn't formally contested them, Your Honor, but yes, I believe most of them are equally unjust. The judge looked at Patricia. Here's what's going to happen. The HOA is going to review every violation and fine assessed to Mr. Lawson over the past 3 years. For each one, you will provide clear documentation of the bylaw violated, evidence that the bylaw is specific and reasonable, and evidence that you've enforced it consistently across the community. You have 30 days. If you cannot provide this documentation, those fines will be refunded. Your Honor, that's highly unusual. So is fining someone for snow on their own lawn, Miss Thornton. Consider yourself fortunate I'm not sanctioning the HOA for harassment. You're dismissed. Patricia grabbed her folder and stormed out of the courtroom. Joyce scurried after her. I stood there for a moment, processing what had just happened. The judge had not just dismissed my case. She had essentially invalidated Patricia's entire enforcement regime. Ellen met me outside the courtroom, barely containing her grin. That was incredible. I've never seen a judge laugh at an HOA before. You hit the jackpot with Mitchell. What happens now? I asked. Now you wait. The HOA has to do the review the judge ordered. If they're smart, they'll refund most of your fines rather than try to justify them. You should also expect some changes in how they operate going forward. Over the next month, things in Meadowbrook Estates changed dramatically. Patricia's behavior became more erratic. She started driving by my house multiple times a day, clearly looking for any violation she could cite. She sent me notices for increasingly absurd things like a leaf on my driveway and a smudge on my mailbox. Each notice, however, was carefully documented and added to my file. Other residents, emboldened by my court victory, started pushing back against Patricia's enforcement. When she cited someone for a fence violation, they demanded evidence of consistent enforcement. When she tried to fine someone for landscaping issues, they pointed out 10 other properties with similar situations. Patricia's power was unraveling, and she knew it. The HOA's attorney must have advised them to cut their losses because 3 weeks after the court hearing, I received a check for $1,200 representing refunds for various fines, along with a terse letter stating that upon review, several citations had been found to be inconsistent with current enforcement practices. No apology, no acknowledgement of wrongdoing, just a check in corporate speak. I thought that would be the end of it. I was wrong. In early May, I came home from work to find an official-looking envelope taped to my front door. It was a notice informing me that the HOA board had scheduled a special hearing to discuss my continued violations and to consider my removal from the community under a bylaw that allowed the HOA to force the sale of properties owned by residents who were persistently non-compliant and detrimental to community welfare. I immediately called Ellen. "They're trying to kick me out of my house," she sighed. "That's a nuclear option for an HOA. The bylaw probably exists, but it's almost never enforced because it's very difficult to prove the necessary standard. They need to show a pattern of serious violations that genuinely harm the community. You having snow on your lawn doesn't remotely meet that threshold. So what do I do? Go to the hearing and defend yourself. Document everything. And honestly, at this point, you might want to consider gathering other homeowners to remove Patricia from the board. She's out of control." The hearing was scheduled for a Tuesday evening. I spent the intervening days talking to neighbors and other residents who were fed up with Patricia's reign. What I discovered was shocking. Patricia had been HOA president for 6 years, and in that time, she had driven away dozens of reasonable people while consolidating power with her small group of loyalists. Elections were held annually, but were typically sparsely attended, allowing Patricia and her allies to maintain control. Mike Peterson, my neighbor who had warned me about Patricia years ago, agreed to help organize opposition. We started a phone tree and email list, reaching out to every homeowner in the subdivision. The message was simple: show up to the hearing, see what Patricia is trying to do, and understand that it could happen to any of us. The night of the hearing, the community center was packed. Every chair was filled and people lined the walls. Patricia looked shocked by the turnout. She tried to start the meeting, but residents kept interrupting with questions and complaints. "Order! I need order!" Patricia banged her gavel repeatedly. "You need to answer for your behavior," someone shouted from the back. Helen Crane stood up. "Patricia, before we proceed with Mr. Lawson's hearing, I'm calling for a vote of no confidence in your leadership as board president. I've gathered signatures from 20% of the homeowners as required by our bylaws to force this vote. Patricia's face went white. You can't do that during a scheduled hearing. Actually, I can. Bylaw 6.8 allows for a no-confidence vote to be called at any board meeting with sufficient signatures. This is a board meeting. The room erupted in applause. Patricia looked desperately at her allies, but Joyce and Robert both looked uncomfortable. They could see which way the wind was blowing. Donald Matthews, the other reasonable board member, pulled out a copy of the bylaws. Helen's right. We need to take this vote before proceeding with other business. What followed was the most satisfying 2 hours of my life. One by one, residents stood up to share their stories of Patricia's harassment. The couple with the wrong mailbox, the widow with landscaping fines, a veteran who had been cited for flying an American flag that was supposedly too large, a young family who had been fined for having children's toys visible in their yard. The stories went on, painting a picture of a petty tyrant who had made life miserable for countless people. Patricia tried to defend herself, but her arguments fell flat. She insisted she was just enforcing the rules, but people kept pointing out the selective enforcement and ridiculous interpretations. She claimed she was protecting property values, but homeowners pointed out that several people had left the neighborhood specifically because of HOA harassment, making it harder to sell homes. Finally, Helen called for the vote. Every homeowner present was allowed to vote, not just board members. The result was overwhelming. 87 votes for removing Patricia as president, 12 votes against. Patricia stood up, grabbed her things, and left without a word. With Patricia gone, Helen assumed the role of acting president. Her first motion was to dismiss the proceedings against me entirely. It passed unanimously among the remaining board members. Her second motion was to call for a comprehensive review and rewrite of the HOA bylaws to remove vague language and establish clear, reasonable standards. That also passed. Over the next several months, Meadowbrook Estates transformed. The bylaw committee, which I joined, worked to create rules that were specific, reasonable, and consistently enforceable. We eliminated subjective standards like aesthetic disruption and visual harmony in favor of clear measurements and guidelines. We established a formal appeals process for violations. We created term limits for board positions and requirements for greater transparency in enforcement. Patricia's allies on the board resigned or chose not to run for re-election. New board members who actually cared about the community rather than power took their places. The neighborhood became noticeably friendlier. People who had been afraid to put up decorations or personalize their properties started doing so. The widow who had been harassed about landscaping got help from neighbors who volunteered to maintain her yard. The veteran's flag stayed up without complaint. I ran into Patricia once more, about a year after the hearing. I was at the grocery store in Aurora when I saw her in the produce section. She saw me too, and her expression hardened. For a moment, I thought she might say something, but she just turned and walked away. I heard later that she and her husband had sold their house and moved to a different suburb. Apparently, she had tried to join that HOA board but was rejected after someone looked up her history. As for me, I stayed in my house at 4782 Meadowbrook Drive. Every winter when it snowed, I plowed my driveway and pushed the snow onto my front lawn, creating whatever size pile was necessary. No one ever said a word about it. The community center installed a small plaque in the meeting room that read, Meadowbrook Estates, a community of reasonable people. It was Helen's idea, and everyone loved it. The case itself became something of a local legend. Ellen told me other lawyers in the area referenced it when dealing with HOA disputes. The story spread through social media and HOA reform groups across Colorado. I even got contacted by a reporter for a Denver newspaper who wrote an article about HOA overreach, featuring my case as a prime example. The article caught the attention of state lawmakers, and the following year, Colorado passed new legislation strengthening homeowner protections against HOA abuse. The law required HOAs to enforce rules uniformly and gave homeowners easier paths to challenge unreasonable fines. It also prohibited HOAs from placing liens on properties for violations under certain dollar amounts without first going through arbitration. While the law did not solve every HOA problem in the state, it gave people like me more tools to fight back. Mike Peterson and I became good friends through the whole ordeal. We started having regular barbecues in the summer where neighbors could gather without fear of being cited for noise violations or having too many cars parked on the street. The community that Patricia had tried to control through fear became a real community based on mutual respect and common sense. Helen served as HOA president for 2 years before stepping down, satisfied that she had helped right the ship. The board that followed continued her sensible approach. Dues were lowered because we weren't spending money on frivolous legal battles. Common areas were maintained properly. Actual problems, like a drainage issue affecting several properties, were addressed promptly and professionally. Looking back, the whole experience taught me several things. First, never underestimate the capacity of people with a little bit of power to abuse it. Patricia genuinely believed she was improving the neighborhood when she was actually destroying it. Second, standing up to bullies, even when it's expensive and stressful, is worth it not just for yourself but for everyone else they're victimizing. Third, most people are reasonable and decent when given the chance. They just need someone to take the first step in challenging unreasonable authority. The snow fine that started everything became a running joke among my neighbors. One Christmas, Mike gave me a snow globe with a tiny house and driveway inside. The inscription on the base read, "Freedom to plow." I kept it on my mantle as a reminder of the absurdity that had somehow turned into a community awakening. I also kept the letter from Judge Mitchell dismissing the case. Ellen had sent me a copy of the official court order, and I had it framed. It hung in my home office, a reminder that sometimes the system works, sometimes judges see through nonsense, and sometimes justice prevails over petty tyranny. The judge's words were clear and unambiguous. The fine was dismissed, the HOA's interpretation was unreasonable, and their enforcement was discriminatory. Years later, when I eventually sold that house and moved to Montana for a job opportunity, I made sure to tell the new owners about the community's history. They were a young couple with 2 kids, excited about the neighborhood but nervous about the HOA. I showed them the reformed bylaws, introduced them to Helen and Mike, and told them the story of Patricia and the snow fine. They laughed at the absurdity of it and were relieved to know the HOA had changed. The day I left Meadowbrook Estates, several neighbors came by to say goodbye. We stood in my driveway, which I had just shoveled one last time that winter, with the snow piled neatly on my front lawn. Someone joked that I should leave the pile as a monument. Someone else suggested a historical marker. Here, Wyatt Lawson defended freedom. We all laughed, but there was truth in the humor. What had started as a ridiculous fine over snow placement had turned into something much larger. A community standing up for common sense and human decency over arbitrary rules and petty enforcement. I never forgot that lesson, and I carried it with me to Montana and beyond. When I bought my new house, I made sure it was not in an HOA neighborhood. I had had enough of bylaws and enforcement and meetings to last a lifetime. But I also knew that my experience in Colorado had been valuable, even if it was frustrating and expensive. I had learned to stand up for myself, to document everything, to find allies, and to trust that most people, including judges, can recognize absurdity when they see it. The $500 fine for plowing snow onto my own lawn became one of the best investments I ever made, not because of the money, but because of what it revealed and changed. It exposed a broken system, rallied a community, and ultimately made life better for everyone in Meadowbrook Estates. And it gave me a story I would tell for the rest of my life, always ending with the image of Judge Mitchell laughing at Patricia's photo of my snow pile and declaring the whole thing ridiculous. Sometimes justice looks like a dramatic courtroom victory with soaring speeches and legal brilliance. Sometimes it looks like a judge examining a grainy photo of a snow pile, shaking her head, and laughing at the absurdity of someone being fined for it. Both are equally satisfying, and both remind us that common sense still has a place in our legal system, even when dealing with the Byzantine world of homeowners associations. That snow pile, that fine, that hearing, they all became part of my personal mythology. Whenever I faced unreasonable authority in my life, whether at work or in other contexts, I thought back to that moment in the courthouse when Judge Mitchell dismissed the case. I remembered that standing up to bullies works, that documentation and preparation matter, and that sometimes the system really does side with the little guy against petty tyranny. Those lessons stayed with me, shaped how I approached conflicts, and gave me confidence that fighting for what's right, even over something as simple as snow placement, is always worth the effort.